Harry inherits a large and dilapidated house from his mother. He moves in and decides to have substantial renovations carried out by Askew Alterations Limited, a local company that specializes in renovating old property. Whilst these alterations are in progress, Harry decides to hold a party to welcome his new neighbors. Barney and his 5-year-old daughter Clara attended. Clara becomes bored and wanders into a room marked "Danger, do not enter," where she is injured. Barney, while looking for Clara in that room, turns on a light switch that has not been completely finished and suffers an electrical shock. Danny, who is aware that Harry's mother kept a wine cellar, goes down to the cellar intending to help himself to get some wine, but slips on a cork on the steps and breaks both his legs. "Now," advise Barney, Clara, "and now what you have to answer in this question. You have to see the application of Occupier's Liability Act, 1957 on given situation, and after that you have to answer the following. Firstly, Harry's duty to visitors including Barney, Clara and Danny. Secondly, the effect of the warning notice. And thirdly, Harry's duty to Danny under Occupier's Liability Act, 1984. Keeping in mind all the questions to be answered, questions should be answered as under: Harry is the occupier of his house, as he has sufficient control over the premises as per Section 1 subsection 2 of the Occupier's Liability Act 1957, as discussed in Wheat v. Lucan, 1966. However, given the extent of control for such substantial renovations, Askew could be an effective occupier, but, for the purpose of this discussion, Harry will be deemed to be the sole occupier. Barney, Clara and Danny are initially Harry's visitors as they are invited. Wheat, Section 1, subsection 1 of OLA 1957, and it is self-evident that Harry's house would satisfy the condition of being a premises, as per Section 1 subsection 3. Harry owes visitors the common duty of care, Section 2, subsection 1, of the Occupier's Liability Act 1957, to take such care as in all of the circumstances to see that the visitor will be reasonably safe in using the premises for the purposes for which he is invited. It is the visitor who must be reasonably safe and not the premises. See Ferguson v. Welsh, 1987. Thus, the fact that repairs are being carried out to Harry's house does not in itself constitute a breach. As far as claim of Barney is concerned, prima facie, it is a breach of duty to allow persons to come into contact with unsafe light switches, but Harry has attempted to discharge his duty via the notice. The notice seems to be insufficient as a warning, as it does not describe the nature of the danger in any way, and so, by Section 2, subsection 4, clause A, would not be enough to make the visitor reasonably safe. However, Harry could rely on Section 2, subsection 4, clause B. This section states the occupier will not be liable for the work of an independent contractor where the occupier had acted reasonably in entrusting the work to an independent contractor and had taken such reasonable steps to satisfy himself that the contractor was competent and that the work had been properly done. The renovation is covered by Section 2, subsection 40, clause B, as it is reasonable to entrust it to independent contractors, and as we are told that Askew Alterations specializes in renovating old property, it would seem that it is competent. The question, therefore, is what, if any, steps Harry ought reasonably to have taken to satisfy himself that the work had been properly done. Despite the words "had been properly done," it was held by the House of Lords in Ferguson v. Welsh, 1987, that it could apply where the work was still being done and had not been completed. The rule is that the more technical the work, the less reasonable it is to require the occupier to check it. Haseldine v. Dorr, 1941, and Woodward v. Mayor of Hastings, 1945. In Harry's circumstances, it would seem that as the work is technical, there is no requirement to check that the work had been properly done, and Harry has discharged his duty by employing reasonable independent contractors, if this is indeed the case. Hence, Barney may not be able to sue Harry, if Section 2, subsection 4, clause B, applies, but he could sue Askew Alterations in negligence. Askew Alterations owes Barney a duty of care under normal answer to claim of Clara is that, by Section 2, subsection 3, clause A, of the 1957 Act, Harry must be prepared for children to be less careful than adults. In Latham v. Johnson and Nephew Limited, 1913, Lord Hamilton stated that there may be a duty not to lead children into temptation. Having said this, if the danger is obvious, even to a child, the occupier will not be liable. Liddell vs. Yorkshire, North Riding, County Council, 1934. Indeed, the broad nature of the duty is that all visitors are to be kept reasonably safe, and that there was no duty to safeguard children from harm from all possible circumstances. West Sussex County Council vs. Lewis Pierce, 2013. With very young children, of course, almost anything can be a danger, but here an occupier will be able to rely on the decision of Justice Devlin. In Phipps vs. Rochester Corp. 1955, it was held that reasonable parents would not allow small children to go unaccompanied to places that may be unsafe. It should have been clear to Barney that Harry's house was in the process of redecoration and hence contained danger that might not be obvious to a small child. Following Phipps, Barney has not acted reasonably, and that Harry was just in relying on Barney to look after Clara. Harry could also argue that the sign "Danger, do not enter" is a warning that discharges his duty under S24A, but to achieve this, the warning must in all of the circumstances be enough to enable the visitor to be reasonably safe. The sign does not seem to be a warning at all, in that it does not describe the danger. It would not be enough in all of the circumstances to discharge the duty owed to a small child, though there may be some scope to turn the child into a non-visitor, and so the application of the 1984 Act may be relevant. It would also be relevant to consider whether injury was sustained due to the state of the premises or as a result of any activity she undertook there, which is unclear on the facts. See Reville vs. Newbury, 1996, and recently Sidorn vs. Patel, 2007. In the latter case, it was held that the statute would not apply and ordinary negligence principles would apply, and so Clara could alternatively sue Harry or Askew in negligence. For the claim of Danny, the answer would be that, although Danny was initially a visitor, on entering the cellar, he became a non-visitor. An occupier may place a spatial limitation on the visitor's permission to enter. The Carlgarth, 1927, and, by implication, Danny must have known that he did not have Harry's permission to enter his wine cellar, and, consequently, Danny became a trespasser when he entered the cellar. Any duty now owed to Danny is governed by the Occupier's Liability Act 1984. By S13 of the 1984 Act, an occupier will only owe a duty to a non-visitor if all three of the conditions in the section are satisfied. It seems unlikely that requirement, A, that of having knowledge of the danger or having reasonable grounds of a cork on the floor would necessarily be known. Cohen vs. Coventry Healthcare NHS Trust, 2006, Ratcliffe v. McConnell, 1999, Rinn vs. Astbury Water Park Limited, 2004. Requirement, B, is arguably not satisfied, as Harry had no reason to suspect that his guests would go down to the cellar. Hence, no duty is likely in respect of Danny's accident in the cellar. You can also rely on Tomlinson vs. Kingleton Borough Council, 2003,